Did you get printed the other day at Woodhaven?
Yes, I did, Your Honor, because you told me to.
Right.
Yep. And I didn't know I had a tether violation, and they arrested me.
The proceeding begins with the judge inquiring if Mr. Elliott was recently fingerprinted at Woodhaven, which he confirms, explaining it was under the judge's orders. Despite complying, Mr. Elliott reveals he was unexpectedly arrested for an alleged tether violation. The judge acknowledges the arrest, but is puzzled by the lack of evidence for the violation in the records.
I see a warrant. I see he was picked up on a warrant while being fingerprinted out of the 3rd Circuit in Wayne County.
Is there a deputy right there?
Yeah.
Deputy, Mr. Elliott was picked up on a tether violation, it says, on the 4th. For the life of me, I cannot figure out what the tether violation is. I read this record, this report here, and it says that he was over there lurking at the police department.
He's being fingerprinted.
I noticed the above subject tracing the location of the Woodhaven Police Department. I contacted Woodhaven Police, did verify subject was there. A detainer was emailed. I was notified the subject was at Woodhaven Police to be fingerprinted. A 3rd Circuit warrant was found and the subject was put into EMU writ status. So this has nothing to do with him. Him being in custody right now has nothing to do with a tether violation. Is that true or false?
I'll have to look, sir. Hold on.
I don't see any reference in there about a tether violation.
Well, it says it in here there was. I mean, implicitly they say it, but I don't see where there was one. I didn't order him not to go back to the Woodhaven Police Department.
Deputy Dr. Marcus Rigel clarifies that Mr. Elliott was arrested based on a warrant issued during fingerprinting, but there's no mention of a tether violation in the reports. Mr. Elliott expresses confusion over the charges, ranging from tether violations to stalking and malicious destruction of property, and mentions his concern about a ticket he needs to pay.
According to the system, it says he's here for malicious destruction and 2 counts of domestic violence. Now, about that report or being a violation of his tether, I would have to even read the report myself, sir. I didn't write the report.
Can I speak?
You're just, Elliot, I want to make sure you don't say anything that incriminates you because you haven't pled guilty to anything.
I know I've been told 4 different things that it is. Like, I don't know what I'm
That's fine. What is it that you're being told?
I'm being told from the sheriffs that picked me up from the Woodhaven Police Department, it was a tether violation. Then, when I first asked the Woodhaven Police Department, when I first got there, they told me it was a stalking charge. I've never stalked anybody. Then, now it's a malicious destruction of property, which I'm paying off. That's from another case at Woodhaven that I'm paying off. And I need to pay that ticket off today as well, which is another problem for me, but that's beyond the point. So basically, I'm very confused. My tether got it. I know it's a tether violation, but I don't know. I'm sorry, Your Honor. I'm not trying to confuse you.
All right, slow down. Just relax. I cannot figure out why this gentleman is in custody.
I have a job.
Mr. Elliott, I'm going to straighten it out for you, sir.
Thank you. I'm really thankful.
The judge advises Mr. Elliott to stay calm as they try to resolve the issue. Reviewing the report, the judge notes Mr. Elliott's compliance with his curfew and the absence of new charges post-February 21st, 2023. Communication with the coordinator and Officer Griffith suggests the arrest may be due to a miscommunication or misunderstanding.
They're saying at approximately 6 p.m., 1900 hours, or 7 p.m., I guess that would be, while monitoring the OmniLink software, I noticed the above subject tracing the location of the Woodhaven Police Department. I contacted Woodhaven and did verify the subject was there. This is a sergeant from the Sheriff's Tether Unit. A detainer was emailed and I was notified the subject was at Woodhaven to be fingerprinted. A 3rd Circuit warrant was found and the subject was put into EMU writ status. So I don't know what the 3rd Circuit warrant's on, but that has to be the reason. But I'm just curious as to why they're putting him in front of me on a tether violation when it appears there was none. The subject was in compliance with his curfew at the time of the arrest, unless the tether violation is for violating a law, and that could have happened while he was on bond, and I ordered him not to violate a law. So I don't I'm unclear. Do we have any other indication that this gentleman was picked up on any other case after he was in front of Judge Hessen actually for arraignment on February 21 of 23 and up through the present? And I see nothing.
I think
there's been some. I think there's been
a misunderstanding, Your Honor.
So do I.
Your Honor, I'm going to ask that.
Do we have any indication that he has any other case pending in Wayne County Circuit Court, the Deputy Marquez?
No, sir, not that I see. None but the current stuff.
Lisa, do you have any indication on anything, including the lien that you're either have run or are running or about to run, that there's any other hold?
No, the lien is printing down there in the courtroom right now. And I looked on the Wayne County site, it only shows these 2 cases it's held on.
So the problem is somebody had made an assumption, and my father used to tell me what would happen if you made an assumption, and it's not a good one. This guy's been sitting in jail for 2 days. Unless there's a hold, I want him released immediately.
Further investigation shows no additional cases pending, supporting the judge's belief that the arrest was a misinterpretation of events. The judge criticizes law enforcement's assumptions and orders Mr. Elliott's immediate release unless there are other holds. However, the judge insists Mr. Elliott be refitted with a GPS tether under the original conditions, emphasizing the urgency to expedite his release.
But this is not right. Look, they got to be more careful down there. I mean, this guy now, he spent 38 hours in jail. I wouldn't want to spend 38 seconds in jail, let alone 38 hours. Now, he's got himself into trouble, but he still enjoys a presumption of innocence here. And now somebody's going to tell me they can't get the tether back on for a day or 2 or 6, and that isn't right either. So do whatever you got to do. Tell him the judge said he wants this guy fitted with the tether first and foremost right now, as soon as possible, so he can get out of there, because he should not have been in custody for the last 38 hours, as far as I can tell.
The judge concludes by instructing court staff to amend records for Mr. Elliott's release with the reinstated tether conditions, expressing gratitude to all involved in clarifying the situation and advising Mr. Elliott to stay out of trouble. This case highlights the importance of clear communication and thorough verification in the judicial process to prevent wrongful detentions.
I stand here before you today to take accountability for my actions. I shed bad light on the office of sheriff. I can only ask that my staff, their families, the community, and my family who is here today will forgive me for the undue stress I caused them. For this, I am terribly sorry. I stood in this court on September 24th and pled guilty to the charges against me, to accept responsibility for my conduct. That day, within minutes, everything that I'd worked for professionally and honorably for 25 years was stripped of me.
Former Pike County Sheriff Charlie Reeder stands before the judge, expressing deep regret for his actions and the stress caused to his staff, their families, the community, and his own family. He acknowledges the seriousness of his offenses, having pled guilty on September 24th, leading to the loss of his 25-year career.
I have, and I now pray that the court will find mercy on me. And I beg the court, if they see fit, to grant me community control, even with the strictest sanctions that I have proven to this court in the past 2.5 years that I can abide by.
Reeder admits to betraying the public's trust, emphasizing his lifelong dedication to law enforcement. He appeals for mercy, seeking community control with strict sanctions, highlighting his desire to be present for his family during significant life events.
I have a couple of questions for you. The big question I have, and is on everyone's mind, I'm assuming, is why did you cut open these evidence envelopes and take the money out, and then in some cases you put it back, although you were caught because the envelopes had been unsealed and sealed again improperly, and the denominations did not match what was taken at the crime scene or from those individuals. I guess, why did you take the money?
The judge questions Reader about taking money from evidence envelopes. Reader claims he used it for community benefits, but failed to document expenditures. The judge points out inconsistencies, questioning why Reader stored money in his vehicle instead of a safe, and highlighting discrepancies in the investigation.
My men and women did not make good money, so some of them would give them $2, $5. I took money from that and I provided it to those people. Now I replaced it in time. The money was not in the safe the day that they came and they did the search warrant in my office. 3 days prior to that, which the state has not included, I had knowledge from my secretary, Kelly Sanders, that the security company was coming into my office, and that office was going to be open to anyone. I removed those monies from that safe and I put it in the back of the F-250 that I drove. Now, the day they did the search
I'm
for it,
sorry, and it would be safer in the lockbox in your car than it would be in a safe?
In an open office?
Which only you have, and a few other people have the combination?
well, ma'am, no one should have had the combination but me. And it strikes me odd that Lieutenant Burchett at the time would make a statement to the state that he'd never seen the accordion file that I provided the state.
Reader admits guilt, but insists he did not profit personally, attributing his gambling losses to personal funds. The judge notes the impact on Reader's family, recognizing them as unintended victims. Reader reiterates his plea for community control, citing his commitment to abide by sanctions and the stress he has endured due to high-profile cases like the Roden murders.
At this time, is it your desire to change your plea from not guilty to guilty?
Do I have to answer that yes or no, or can I make somewhat of a statement that's
That is a yes or no answer, sir.
Will I have the opportunity to say anything further?
If it is your intention to change your plea from not guilty to guilty, certainly you'll have an opportunity to make any statement. But if it is not your intent to enter a guilty plea at this time, then I'm going to set your case for jury trial, and you're going to stop wasting my time and everybody else's time this afternoon.
Ma'am, I'm not trying to waste your time.
And then is it your intention to enter a guilty plea at this time or not, sir?
No. Why am I wasting your
Mr.
time?
Chambers.
In Breckinridge County, Kentucky, former Sheriff Todd Pate stands before Judge Janet Crocker, facing charges of assault, DUI, second offense, criminal mischief, and leaving the scene of an accident. At 51, Pate is in court to change his plea from not guilty to guilty, reducing his potential sentence from 15 years to 75 days in jail.
Let's get back on the record and see if we can sort this out. At this point in time, what is Mr. Pate's decision with respect to his guilty pleas?
So I believe I'll just let him answer that question if it pleases the court.
All right. So, Mr. Pate?
Can I say a few things, or?
I need to understand what it is that we're doing here today, Mr. Pate.
Yes, I had every intention of coming in here today and entering a guilty plea. It's difficult for me to enter a guilty plea for a lot of reasons, and I don't want this court to think that I am trying to minimize any responsibility that I had in this situation that occurred.
Judge Crocker asks Pate if he wants to change his plea. Pate hesitates and requests to make a statement. The judge insists on a simple yes or no, warning that if he doesn't plead guilty, his case will go to trial. Pate's continued questioning frustrates the judge, who calls a brief recess.
Is it your intention today to enter this guilty plea?
And if I could address,
This is either a yes or no. Are you going to enter your plea or not?
I guess everybody thinks it's funny. Let me just plea and get it over with for everybody. Plea to something that I absolutely do not feel good about, but I don't want you to try to send me to the penitentiary for years and years. You can sleep with it, I can sleep with it.
After reconvening, Pate expresses internal conflict, stating that while he initially intended to plead guilty, he feels the assault charges unjust and added due to his former position as sheriff. Despite feeling coerced, he reluctantly agrees to plead guilty.
And Mr. Pate, I'm talking at this point in time.
Okay, I'm sorry.
At this point in time, I'm going to sustain the Commonwealth's motion to revoke his bond. He will be taken into the custody and housed in the Breckinridge County Jail.
Your Honor, if I may speak to Mr. Chambers' motion to revoke the bond.
I've already ruled. I've already ruled at this point in time.
Ma'am.
We're done at this point in time. He's going into jail today.
Judge Crocker, losing patience, revokes Pate's bond, ordering him into custody. Pate's attorney's objections are overruled. Ultimately, Pate pleads guilty and accepts a 75-day jail sentence with credit for time served. This case highlights the emotional struggles and complexities of the judicial process, even for a former sheriff.
State your name and your employment for the record, please.
I'm Officer Radcliffe Police Department.
And how long have you been a police officer with Radcliffe Police Department?
A little over a year.
All right. Do you have any other police experience?
Yes, I was an MP for 9 years in the Army. 3 years of that I was a military police investigator.
And so you've had training as a police officer, right?
Yes.
What training have you had?
DOCJT, and then my in service this year was interviewing and interrogations.
Okay. DOCJT, is that the state of Kentucky's police training component? All right. And have you, would you estimate how many DUI stops or investigations you've been a part of since being with Radcliffe, please?
Approximately 25.
Okay, just over the past year or so that
Yes.
you've been, all right. Now, did you have specialized training in DUI investigations?
No.
No.
The court session begins with formalities, and prosecutor Mr. Moore calls Officer Megan Sutherland to testify about the night in question. After being sworn in, she recounts responding to a noise complaint on Lincoln Trail Boulevard. Upon arrival, she spoke to the resident, and party attendees began leaving. She initially saw David Symington walk past, but didn't interact with him until assisting her lieutenant with a traffic stop involving Symington.
Okay, let me back you up to when you came to the address on the noise complaint. Describe, you said you spoke to someone there?
Yes.
How did you approach that individual? How did you have contact with them?
I went to the front door, knocked on the door, announced myself, Radcliffe Police Department. I'm not sure who answered the door, but I asked for the resident, the actual person that lived there. He came to the door. I was trying to talk to him, couldn't have a conversation because it was so loud. So we actually stepped into the hallway. He had pulled the door up behind him, and I explained to him the process.
When you say hallway, was this an exterior area or an interior area?
Hallway of the building.
Okay. You're outside.
Outside of the apartment, but it's inside the building in the hallway.
Gotcha. Okay. All right. And so someone stepped out. Okay.
Yes.
You don't recall
I don't remember
who that person was. Okay. And describe what conversation, if any, you had with him.
Explained to him why we were there, that we had received another noise complaint for his residence. It was the first time I went to his house, but there had been an earlier call. And I explained that he could be cited for city noise ordinance violation because he was disturbing his neighbors. And he said, "Oh, I don't want any part of that." So he went back inside to his residence and told all his friends and the partygoers that they needed to go.
At the police station, Officer Sutherland read Symington the implied consent form and observed him for 20 minutes before administering a breathalyzer test, which showed a BAC of 0.132. She confirms the proper functioning and calibration of the Intoxilyzer 5000 EN machine.
Did he talk to you or ask you anything?
Not that I recall. No. There was several people that all walked out at once, and none of them had anything to say to me. I think I may have gotten some head nods, but nobody spoke to me.
Now, I believe you already testified that on May 30th of 2015, you were trained and certified in the operation of that instrument. Is that correct?
Yes, sir.
And was the test performed in accordance with standard operating procedures and the manufacturer's instructions?
Yes.
All right. And let's see, during the 20-minute observation period that you described, did the defendant introduce anything into his mouth or nasal passages that you observed?
No, sir.
See him regurgitate or anything like that? All right.
During cross-examination, defense attorney Mr. Foreman questions Officer Sutherland about potential coaching, details of the noise complaint, police procedures, and the breath test's validity. He scrutinizes her memory, interactions, and observations to cast doubt on the prosecution's evidence. He also challenges procedural accuracy and the machine's maintenance records.
Now, would you explain to the jury or just describe what is the first reading on that slip?
The first reading is the air blank, .000.
And what is the next reading on that slip?
Calibration check, .080.
And what is the next entry on that slip?
The next entry is an air blank, .000.
Now, skip down to the last one. What is that?
That is also an air blank, .000.
Now, what is the 1 second from last?
That's the subject test, and that's .132.
And is that the actual reading of the defendant's breath after blowing into the instrument?
Yes, sir.
Please read that result again.
Subject test, .132.
Objection.
Without objection, Exhibit 3.
Have you had any conversation with the prosecutor?
Yes, I have had conversation, and he made it very clear that we are not to discuss anything that was happening.
Thank you. You responded to a call from dispatch, correct?
Correct.
And that location was 1204 West Lincoln Trail Boulevard. You are aware, based on what the dispatcher has told you, that this is the second complaint. How many people did you see start to pour out of the place?
Maybe 6 to 8 people, 6 to 10 people.
And how many non-police cars were parked in the front of the apartment or the back, whatever you could see?
I don't know the exact numbers, 10 to 15 cars, but there's a
Just an
parking lot.
approximate is
There's
fine.
a parking lot that adjoins with another apartment building, so there are several vehicles out there.
Thank you, ma'am. May the witness be finally excused, or does she need to remain available for potential rebuttal? What that means is that we need to keep you in the courthouse, but you must continue to remain outside the hearing of other testimony and not discuss your testimony or any others in case you might be called later in the day. Thank you. And Mr. Moore, other witnesses?
Mr. Moore redirects to clarify points raised by the defense. The judge then decides if Officer Sutherland needs to remain available for rebuttal and instructs her to stay within the courthouse.